This will be an analysis of question 2 from the July 2007 bar exam. It is a torts question and specifically a products liability question. Now, in this question, the events are that a customer, a person named consumer, bought a cold drink blender and put hot liquid in it, turned it on, and the top blew off. She got scalded. The blender also had instructions on it, said do not fill above 2 inches from the top. She filled it all the way to the top. Also, the top of this blender did not have a lock top. It's just a little friction top fitting there. So she sued the cold drink blender manufacturer, and she sued the retailer from whom she bought the blender, claiming strict liability and negligence, and negligent design in particular. And she is suing those two people, and I think that's it. Suing both for strict liability and negligence. Now, the manufacturer, one of the defendants, has made a motion to dismiss the complaint, and retailer has also made a motion to dismiss consumer's complaint. Manufacturer says, I want the complaint dismissed because what she did was misuse of the product. Obviously, the problem there is going to be whether or not her use was foreseeable misuse. Secondly, the manufacturer says, I want you to dismiss because it was her own lack of care and not following the instructions that caused her harm. And is that going to be a sufficient basis for dismissal? And the answer is probably going to be no. And thirdly, they say that the blender complied with federal standards, and therefore it was not defective. Let's look at all three of those claims, and then let's look at the claims of the retailer. First, the manufacturer says that is making a motion to dismiss. Now, it's very important for you to understand and remember that when one makes a motion to dismiss, you're not saying that I win by the preponderance of the evidence. You're saying this is a motion to dismiss because the other side doesn't even have a case. There are no triable issues of fact, and therefore the case should be dismissed. And so when you do the analysis here for the bar examiners, since you're responding to a motion to dismiss, all you have to do is to show what the triable issues of fact are, and therefore the manufacturer should not be entitled to a dismissal. Now here, the manufacturer is saying that the case should be dismissed because the consumer misused the product, and the issue there, of course, is whether or not this was foreseeable misuse, and you need to discuss that. Obviously, you can think of pros and cons and do so. Secondly, if the use of this blender with hot fluids if it's within the foreseeable misuse, then is it defective when it's used in that way? For that, it would be a design defect. There are two main theories as to how you determine if there is a design defect. The ALI is the majority view, and it uses these factors. California, one or two other states, use the consumer expectation test. In the ALI test, majority view, the factors are usefulness of the product. Some products are a lot more useful than others, and of course the more useful the product is, the more you allow some risk because of that. you compare cigarettes to a medical product, and the one is much more useful than the other, so you tolerate a little more risk. Secondly, functional utility. This is asking, is the dangerous nature of the product necessary in order for it to be to function? For example, knives have to be sharp, and the dynamite has to explode, and so forth. So the functional utility is the next factor. Third factor, psychological utility. If you get just a little bit of improvement in safety, and the product has to be much, much uglier to do that, should you do it or not? Just discuss it. Social cost. This factor is saying how many people have already been injured by this product, compared to whatever value this product has. And here, the cost of redesign and also the cost of what the new product, how much it would be increased. The cost of the product will be increased by the design. So you use these factors to discuss the question of whether or not the product was defective when it's used with hot water. The consumer expectations test is a test which simply says, was the product more dangerous than a reasonable consumer would expect? Obviously you can argue that both ways. So you see then that whether or not the product has a design defect with all these factors, these are surely tribal issues. And so they should not get their motion to dismiss, even if they're using the consumer expectation test. That's a tribal issue also, and therefore the motion to dismiss for this reason should not be granted. Additionally, you were asked in the second part of the question that the manufacturer says, we want to dismiss because it was her own lack of care that was a cause of her injury. Well, the consumer's lack of care means that the consumer was maybe contributory negligent, but you don't get a dismissal for that. Okay, it simply reduces the person's recovery. In a comparative negligence jurisdiction, you just get a reduction in recovery. In the old days, where contributory negligence was around, it would completely defeat the person's cause of action, the plaintiff's cause of action. But nobody does that anymore. Next, the manufacturer says the product is not defective because it meets governmental standards, and that's evidence only, nothing more. Now let us move to the retailer's motion. The retailer's motion says the retailer played no part. The retailer says, I move to dismiss the complaint against me, the retailer, because I played no part in the cold drink blend in making the blender and shouldn't be responsible for its design defect. Well, is the retailer entitled to a dismissal? Well, you know the rule. The rule is that on strict liability, that everyone in the commercial chain of distribution is liable if the product was defective when it left that person. And therefore, retailer is not entitled to dismissal on the strict liability claim. However, a consumer is also claiming negligence against the retailer. And I think this should be dismissed. And the reason it should be dismissed is because everyone is responsible for their own negligence. And there's nothing in the complaint, any place in the record, where the consumer has claimed that retailer acted negligently. And so there's no claim against retailer for negligence, and it should be dismissed. Now, obviously, you've got to fill in the details, and you can see that the bar examiners want you to know these lists of things. I'm seeing more and more exams where they want you to know these kind of lengthy lists of things, list of factors. I see several recent exams where that's more the case now than it used to be. So when you're learning things, you've got to learn all the elements and analyze by the elements. Don't analyze by the fact. Always stick to the structure. Follow the structure. If you don't know what you're doing, if you read a question, you have no idea what you're doing, follow the structure. And the structure is the way you go about analyzing a question in that area of law. And that's the end of this video.